Proclaimed the most magical place on Earth, Walt Disney World attracts millions of guests a year. Unfortunately, a trip to the park isn't always filled with pixie dust. In Walt Disney World vs. Wood, we'll explore whether a defendant like Disney can be responsible for all damages suffered by an injured guest, even with comparatively minimal fault. Aloysia Wood and her fiancé, Daniel Wood, visited Disney World in 1971. While driving around the Grand Prix attraction, Daniel rammed the back of Aloysia's vehicle, injuring Aloysia. The two subsequently married, barring Aloysia from recovering from Daniel. Aloysia sued Disney for negligence in a Florida state court. Disney sought contribution from Daniel. Using a comparative negligence theory, a jury found that Aloysia was 14% at fault, Disney 1%, and Daniel 85% at fault for Aloysia's injuries. The jury also concluded that damages amounted to $75,000 because Disney shared some level of fault based on joint and several liability. The trial court entered judgment against Disney for the combined 86% of damages attributed to all defendants. Disney moved to reduce the judgment to 1% of the damages, arguing that joint and several liability was inherently unfair when comparative negligence was applied. The trial court denied the motion, and Disney appealed to the 4th District Court of Appeal. The Court of Appeal affirmed but certified the question to the Florida Supreme Court.